Welcome to the Lawsome Sauce podcast, your go-to for breaking down today's most compelling legal stories that are shaping the foundations of tomorrow. I'm PJ.
And I'm Harper. Our special guest today is Charles Garabedian of Mark, Migdal, and Hayden.
Hello everyone, thank you for inviting me on to the Lawsome Sauce podcast. You can call me Charlie.
Welcome, Charlie. It's great you could join us for this case. Stay tuned, everyone. We'll be picking Charlie's brains later on in our show.
In today's episode, we're looking at a case that highlights the power of non-compete agreements and the lengths businesses will go to protect their competitive edge. This is Day versus Hydrologic Distribution Company, pending in District Court of Appeal of Florida, 2nd District.
It's a case about employees leaving for greener pastures, and their former employer saying, "Not so fast." Let's break it down.
The case starts with Hydrologic Distribution Company, a major player in its industry, and 4 former employees, including Jeffrey Day, who left to form a competing company.
Before leaving, the employees had signed agreements prohibiting them from soliciting Hydrologic's customers or employees and from using confidential information. Hydrologic claimed they broke those promises almost immediately.
Specifically, Hydrologic accused the employees of targeting its customers in the Tampa area, poaching other employees, and using proprietary data from its internal software system.
That software, called Eclipse, was described as the lifeblood of the company, containing sensitive customer data, sales history, and credit information. Hydrologic argued that this information gave the former employees an unfair advantage.
Let's talk about what Hydrologic wanted from the court. They filed for a temporary injunction to stop the former employees from working for the new company, soliciting customers, or using confidential information.
Under Florida law, restrictive covenants like non-compete agreements are enforceable if they're reasonable in scope and protect legitimate business interests. Hydrologic argued they had a right to enforce these covenants to safeguard customer relationships, proprietary data, and employee retention.
The former employees pushed back, arguing that the agreements were overly broad and that Hydrologic hadn't shown legitimate business interests or irreparable harm.
So, what did the court decide? After a detailed evidentiary hearing, the trial court granted Hydrologic's motion for a temporary injunction.
The judge found that Hydrologic had clearly demonstrated legitimate business interests, especially the proprietary nature of its Eclipse software. The data in Eclipse wasn't just confidential, it was critical to Hydrologic's operations and profitability.
The court also ruled that the former employees hadn't provided enough evidence to rebut the presumption of irreparable harm. Florida law presumes harm when a restrictive covenant is violated, and Hydrologic's case fit the bill.
On appeal, the former employees argued the trial court got it wrong, but the appellate court disagreed. They upheld the injunction, affirming the lower court's findings and emphasizing the evidence of legitimate business interests.
We invited Charlie because some of his favorite cases are non-compete cases. Charlie, what was it about this case that you found interesting?
One of the key questions in non-compete litigation is whether a restrictive covenant is backed by a legitimate business interest. Employers typically use non-compete agreements to protect things like customer relationships, confidential business information, and employee training. And as you discussed earlier, that issue was front and center in Hydrologic. The court found that Hydrologic's non-compete agreements protected legitimate business interests. The key factor was that Hydrologic's employees had access to password-protected internal software described as the company's central nervous system. This system contained crucial data, including vendor information, sales history, customer spending habits, and credit limits, which the court found was important to the company's operations and profitability. Defendants in non-compete cases often argue that access to client data and industry know-how don't qualify as legitimate business interests, but Hydrologic really pushes back against that argument. I think it's a case worth keeping in mind for anyone dealing with non-compete disputes.
Thank you, Charlie. So, what can we learn from this case? First, if you're an employer, restrictive covenants can be a powerful tool, but only if they're tailored to protect specific and legitimate interests like customer relationships or proprietary data.
Second, for employees, it's critical to understand what you're agreeing to when you sign a non-compete or confidentiality agreement. Violating these terms can lead to serious legal consequences, even if you think the terms are unfair.
And third, This case shows the importance of evidence. Hydrologic's ability to present detailed documentation of its business practices and the importance of its software played a huge role in securing the injunction.
Ultimately, courts look for balance, protecting businesses from unfair competition while ensuring agreements don't overreach. It's a delicate line to walk.
That's all for today's episode. The Day vs. Hydrologic case highlights just how far businesses will go to protect their competitive edge, and how the courts play a role in drawing the boundaries.
If you've got a legal story you'd like us to cover, reach out to us. We're always here to explore the twists and turns of today's legal battles.
But remember, we are not able to give you legal advice.
For that, you need to contact your lawyer.
Nothing we discuss should be construed as legal advice.
And anyway, you should never take legal advice from kids.
Thanks for tuning into the Lawsome Sauce podcast.
Until next time.
Stay curious and stay informed.
Thanks for having me on the podcast, and I hope to be back soon.